Mr. Goudie, would you address the jury, please?
May it please your lordship, gentlemen of the jury, Mr. FitzPatrick suggested to you that there was a tactical advantage in following him. If I have a tactical advantage, he has the advantage of eloquence. I think probably they balance. It's been a long day, and I'd like, if I can, to shorten things for you, at least insofar as my words to you are concerned, to the extent that I can in a case that is a serious case and a particularly important one to Mrs. Paget, my client. I can perhaps do it this way by eliminating many general remarks that I might otherwise have made by simply echoing all of those things that my friend said with respect to our system of justice, your place in it, and the impartiality which you must, and I'm sure will, bring to your deliberations. Beyond those generalities, which I subscribe to and echo, there are, as you may guess, substantial differences of approach that we have in this case. At the outset, I indicated to you, by way of a summary, what the plaintiff's case was all about and what we would attempt to show for the plaintiff. You've seen the evidence now, and it's on that evidence, and only that evidence, and inferences that you may draw from it, that you'll base your decision. But it's my function to show to you how the theories of the plaintiff's case are supported in my submission by that evidence, and to assist you in your deliberations toward an end which I submit is a just one on those facts. And I'll do it, to some extent at least, with reference to questions that you'll have before you. They've been prepared. You'll have them with you in the jury room. His lordship will explain to you what you must do with them, but it might help keep my words in line if I deal with them as they are here, but not in the order in which they're here. The matter of the assessment of damages is something which you will have to determine. His lordship will tell you what law you must apply in that consideration, but it will be you who writes down the figure, and it will be that figure which the plaintiff must be satisfied with. And satisfied with once and for all. She hasn't an opportunity to come back to you at some later stage and say, just a moment now, you took into consideration something in your deliberations which didn't pan out. If it should occur to you that she might remarry, and she doesn't, she can't come back to you and look for more. So that you must, as my friend said, be impartial. You must, as he also said, arrive at your decision on the balance of probabilities. Don't let vague possibilities enter into your deliberations. And remember that this is a once and for all award. There can be no changing the award at this level. And because you have to deal with the assessment, regardless of your findings on liability, I'd like to dispose of that first in my comments to you. And as I said at the opening, there are the special damages. They're agreed upon. You can leave it to his lordship to incorporate them into the assessment at the end, is perhaps the simple thing. There are damages under the Trustee Act. You'll recall I spoke of damages for the pain and suffering that Robert Paget endured prior to his death. I don't think there's any necessity to run over the evidence as to that in detail. You've heard a very lucid description of the nature of the injuries, the duration of them, the fact that it wasn't possible to see Paget completely without pain because of the chest injuries, which made it necessary that the sedation be of a lighter sort and that he be moved from time to time. He underwent, in my submission to you, significant pain for which you must assess a dollar amount by way of compensation just as though he had recovered at the end of 2 weeks rather than died. And there is a specific question as to what your assessment of that would be. I'm not at liberty to suggest figures to you, and you'll realize because of that I can't help you in that way, although I might choose to. Far and away the more significant, and in my submission to you, the most significant aspect of this case is the matter of the damages that arise by reason of the death of Robert Paget. And as my friend says, however tragic the loss of a husband or a father is, you have to approach it on the basis that you're inquiring not what a severe emotional trauma that is, but what a substantial financial loss it has been. And in thinking of that financial loss, bear in mind that you're thinking not only of the financial loss to the widow, but if you feel the facts warrant it, and I suggest to you that they do, a financial loss to the children. They had enjoyed their father's support on the evidence to a fairly substantial degree. He had seen to their education up to this stage. There appears to be every reason to believe that he would have continued to see to that, and that that education in the case of each of them would have continued for a reasonable length of time that you'll have no difficulty judging in your experience. So that there's his contribution to them, his contribution toward his wife's welfare, and in total, the sum financial contribution of the family, which has now been lost completely. How do you arrive at that? It's my suggestion to you that you've got some fairly readily followed guideposts that you can employ. You know what he was earning at the time of his death. And if I misstate any of the evidence, I hope you'll accept that it's done inadvertently. And you'll remember the evidence, and you must follow your own recollection of it and not what I say to you. He was earning $12,000. His net after taxes was $10,000. And in my submission to you, from all the evidence before you, it would seem that the lion's share of that, all but for a relatively small portion, went for the financial benefit of the family. His personal expenses were minimal, and only those need you deduct from the gross amount in order to arrive at the extent to which the family was financially dependent on him. Now, it might be simple for you to stop there and say, net $10,000, subtract something for his own expenses. But there's another consideration I suggest you have to make, and that is that the evidence is he would have gone on in the ordinary course of events, notwithstanding the fact that you may feel he had no likelihood of becoming a partner, that he was the worst things that my friend said he was. Even taking into account those things, in the course of 5 to 7 years, he would have progressed in a normal, orderly fashion to a top of $18,000. So that whatever your view as to his expectancy is, and I'll deal with that in a moment, it's my submission to you that the figure you have to take into account is not his present income, net after taxes, allow something for his own expenses, but some sort of figure which takes into account the probability of a progression in his income. Because if he had lived and if he had progressed, his family would have shared in the benefits of that progression, and their ability to share has been terminated. Now, we come to the matter of life expectancy. You've heard not markedly different evidence from the two doctors, but I think significantly different in view of the nature of the case. It's my submission to you that the evidence to be preferred is that of the doctor who might well have been called upon to treat this man had he not been killed. I don't suggest that he would have been, but I think if we look to the person who might have treated, rather than the person who is simply concerned with his diseased tissue, that we've perhaps got the best evidence And if you can readily see what the best evidence is, then that's what you should follow. My submission to you. We have statistical information on which both doctors rely. There's a difference in their interpretation of it. It was difficult, so I submit to you, to be absolutely sure of just what statistics Dr. Anderson spoke of. We can be abundantly sure that the statistics that Dr. Meekins spoke of are those most recently available. That was his evidence. And they deal with patients who were studied between 1950 and 1970. I'm sorry, 1920 and 1950. They're not totally reliable statistics in terms of their direct application to this case because there are variables that aren't considered or that are considered in it that you don't have to consider in this case. Most of those figures, if I understood Dr. Meekin correctly, and it's for you to judge what he said, are mortality figures which take into account not just death because of myeloma, but death for a variety of reasons. Bearing in mind that Paget hadn't any other systemic disease, apparently, query whether or not he isn't in a somewhat better than average situation within those statistics. Those statistics, as my friend was careful to point out, start from a time when the disease is diagnosed. So that, and we don't know how long the disease may develop in any given case before it's diagnosed, but we do know it hadn't been diagnosed in this case, nor were there apparently any symptoms. So that if we take the particular case, we have certain things going for us that weren't going for those people who form those statistics. First of all, we have a person who isn't probably going to die from some other cause. We have a person who is of a median sort of age, 48. Those statistics included old and young alike. We have a person who we must consider in light of today's medical knowledge, which is advanced in the doctor's view over that of 1950, certainly that of 1920. Chances of survival are now greater. If we look at Dr. Meekin's average, which I submit we should do, of 5 years, we must add to the beginning of it, as my friend said, a period of, who knows, a year, 2 years, to give this particular man's disease a chance to come to the fore and be diagnosed. And it's my suggestion to you that we add something at the end, too, to take into account the fact that he isn't suffering any other disease, that he is of a relatively young age, and that there have been advances in medical technique and treatment for this disease. So we've got 5 years plus something at the beginning, plus, in my submission to you, something at the end. And the something at the end may be a very significant something, because if you recall, Dr. Meekin said that there was, in his professional opinion, and he's the expert who treats these people, a reasonably good chance that on diagnosis with adequate treatment, there might be a cure, or a control, at least, of the disease. Now, is it a probability which you feel you can give as a benefit to the plaintiff to consider that he might well have been diagnosed and might well have been cured, and that his life expectancy might be one of the longer ones in that group of statistics? And you'll recall that there were some who lived as long as 26 years, and that's longer than he was likely to live statistically without the disease. So that it's my submission to you that there is every reason, on the basis of probabilities, to take a longer and a significantly longer than the average life expectancy. How does that help you? If you think then of the actuary's evidence, you will recall, and I grant that it's difficult to remember all of the figures, that he gave various figures as the sum of money required to produce $1,000 a year at various rates of interest for a given length of time. My friend, in cross-examining, the actuary suggested that there were abundantly safe, readily available investments that would produce 9% a year. Now, you're entitled to draw on your own experience as everyday people to determine how likely it is that this widow can find such a high-paying investment, which will give her a guarantee, because she's entitled to a guarantee of the same amount of money that her husband would have brought into the family. Mr. FitzPatrick doesn't have to come up with the investment, and you should only hit on such a high rate of interest if you genuinely feel it's probable that that is available to you. It's my submission to you that a much more realistic interest rate, having regard for all the contingencies that affect interest rates, would be, say, 6%. Now, we know that for 10 years, it would cost $7,802 today to produce $1,000 for each of those years. And if you want to find out how much per year, if you want to find out what it would take today to produce 3,000, 4,000, 8,000, 10,000, you need only multiply whichever number of those you feel is the amount that he contributed to his family times this number, which you may not recall, but which was in evidence. At 6%, it would require $7,802 to produce $1,000 a year for 10 years. It's my submission to you that you apply to that a figure that seems a reasonable one to you, having regard for all of the evidence as to life expectancy. And that having done that, you've been fair to the defendant, as my friend urges you to be and as you must be, and you've been fair, or you've approached the matter on a fair basis to the plaintiff. Now, that deals then, as briefly as I feel I can, with the matter of damages. We come then to the question of liability. His Lordship will explain to you, and I will only very briefly in order to make the point, that there is a different consideration applies to the liability of the defendant from that applying to the liability of the deceased. Fairly clearly on the evidence, Mr. Paget was standing on the road or adjacent to it. That makes him a pedestrian. If a motorist strikes a pedestrian, then it isn't for the pedestrian to prove the motorist was negligent. It's for the motorist to satisfy you on the balance of probabilities that he was not negligent. That's the onus of proof. And the onus in this case is in favor of the plaintiff. If you're not satisfied on the balance of probabilities that there was no negligence on the part of the defendant, you need only say no in answer to the first question that's before you. That's my submission to you, that he's a long way short of satisfying that onus. And just to deal with the evidence quickly, surely it's this. And in dealing with it, I should say, perhaps as a preliminary, as to what happened at the scene of the accident, look for physical facts, because they can't really be changed by the parties. Look for the evidence of people who don't have an axe to grind, perhaps the police officer. And when you're considering the evidence of those people who have an axe to grind, consider, did they impress you as credible witnesses? And one way of testing that matter of credibility is, were they consistent? Had they always given the same story? Or had they changed it from time to time, perhaps to suit their best interests? As to Mrs. Paget's evidence, she wasn't attacked in any sense on the basis of having contradicted herself at any earlier time. You'll recall that with respect to certain aspects of his evidence, which I submit were pretty cogent, the defendant, Bright, had altered his evidence for whatever reason we really can't be sure, in various ways. This is a 50-mile speed limit zone. Today, his evidence was that he was traveling 50 to 55. On discovery, he was traveling 55. To the police officer, right after the accident, he was traveling 60, 65. Which will you accept? My submission to you that the first estimate is, if anything, the closest to correct and probably still conservative. Virtually either way he has it, he's traveling in excess of the speed limit. Now, that's a speed limit for relatively ideal conditions. This is a dark night. It's a dark night it's dark. Visibility's good. But it's a stretch of road where not only is he exceeding the speed limit, but where he's disabled himself somewhat in his own judgment from seeing as well he might. He recognized the wisdom or the need of having high beams on where he could, and yet he drove for a quarter of a mile without them. It's my suggestion to you that if he hadn't, he'd have seen the vehicle much sooner than he did, and that we've got then two considerations going. He was traveling too quickly. He didn't keep a proper lookout. Now, beyond that, he says he didn't know that when you slam on the brakes and lock the wheels, you skid straight ahead. If he didn't, query whether he should have been driving at that speed. That's a pretty commonplace piece of knowledge for a driver. And if he had the knowledge, would it not have been a simple matter for him, keeping control of his car, to avoid a collision, seeing the problem from 200 feet, if he had acted in a reasonable fashion and was a reasonably prudent driver? I suggest to you that he was not, and that he didn't respond in the way that he might have done. And those are all aspects of his negligence, but you don't need to stipulate in what respect he was negligent. On the evidence in my submission, you can only find that he fails to satisfy you that he wasn't negligent. The other question which remains to be answered can, in my submission, be answered equally readily with the opposite answer, and that's whether or not there was negligence on the part of the deceased, Robert Paget. Someone says that hindsight is 20/20 vision, and it's awfully easy for us to exercise the wisdom of hindsight from this side of the accident, rather than to consider, as we must do, the accident at the time it occurred. It's a very simple thing to say that if the car hadn't been positioned on the road as it was, there would have been no accident. Since it was where it was, since the accident happened, therefore there's negligence on the part of Paget. And his lordship, I think, will have something to say to you that, to the effect that the actions of the of the deceased, must, before they can be considered to be negligence in law, be an effective cause of the accident. They must really have contributed to the net result in a legally effective sense. It's my submission to you that that isn't the case with respect to the activity of Paget. It would have been nice if he had pulled off the road further. There might not then have been an accident. But was it unreasonable, and you're really here to test the reasonableness of his conduct, for him to stop where he did? The police officer stopped even further on the road, said he would have been reluctant to pull over further because he's seen too many cars go in the ditch. So maybe not as unreasonable as my friend suggests for him to have stopped where he did. Having stopped there, we know his taillights are on, or at least I suggest to you that we do. The passenger in the defendant's car had no difficulty seeing them as soon as she became aware of a problem. One wonders why Bright didn't. One wonders if he saw them at all in light of his discovery evidence. They were there to be seen, in my submission. Something had been sufficient warning for the various vehicles, be it 5 or 8, that went by traveling the same direction during the interval that the tire was being changed. Now, you may think Mrs. Paget's estimate of the time that they were there is just a little bit long. That's something for you to decide. However long it was, We know it was long enough to change the tire. You're men of general experience. You've changed tires. You know how long it takes. You're entitled to draw on that experience to determine in your mind how long the vehicle was there and how great a hazard it constituted when 7 or 8 cars went by, apparently without difficulty. 2 of them stopped to see if they could render assistance. Does that sound like a situation of sufficient danger on the highway that Mr. Bright ought, as a reasonable person, to have done other than he did? In my submission to you, it isn't. You're asked if you find that there was negligence on the part of Bright. My submission, I'm sorry, on the part of Paget, I submit to you that there was no negligence and that nothing he did or failed to do was in any sense an effective cause of the accident, that the sole effective cause was the obvious neglect on the part of Bright, and that because of that negligence, Paget died, and because of his death, the plaintiff and her children have suffered a serious financial loss, which you can best measure in terms of a life expectancy something better than the averages you've heard of, applied to an investment at a reasonable rate of interest, say 6%. And in my submission to you, gentlemen, if you take that approach, the evidence will well support your decision, and you need have no concern with the prospect of you in any way weakening the system of justice that we all love so dearly. Thank you.
Members of the jury, we have now reached the stage in this trial where your final duties must be performed by you. I should say at the outset that I don't think there's any more important duty that a citizen of the community can do than perform services as a jury or as a juror. Undertaking that duty, citizens of the community become participants in a very real sense in the administration of justice, because each individual citizen becomes a judge, as truly as I am a judge, even though the appointment is for one case only. Because of this fact, it is important to the community and to the parties in this action that jurymen approach their duties with a high sense of responsibility. They must try, and you must try in this case, the issues solely on the evidence that is placed before you. The case must be decided on the evidence without fear, without favor, without passion, and in a very real sense of fairness. The juror must approach his duties in the way he would ask an honest judge to approach a case in which he was involved. I said at the outset, and I just say again briefly, that you must not let your minds be affected by any knowledge that you may have of this case from any source other than the evidence which has been given before you. While our duties are similar in that we all are judges, we have clearly defined roles to play. You are the judges of the facts. You must decide the factual issues. I, on the other hand, am the judge of the law. While I must take the facts as you find them, you must take the law as I give it to you. if I state something to be a proposition of law, you must act upon that, even though it may not appear to you to be a proper law. You must, as I say, apply the law as I give it to you, and I must accept your decision and your findings on the facts. In a general way, members of the jury, I ask you to take into account all of the evidence which has been given in this case. You have seen and heard the witnesses in the witness box, and it is your duty to decide what evidence you will accept. That is one of your most important functions. To the answer to any one question, the answer should be entered into the sheet of paper that you will be given, and that will constitute the jury's answer to that individual question. I ask you to consider the issues carefully and to decide this case solely upon the evidence which you have heard in this case. If after you retire, you require any further instruction from me on any point, you need only indicate to the sheriff's officer, who will be waiting outside of your jury room, and he will summons court so that you can have any such question answered. I ask you now to retire to your jury room to consider the answers to the questions that have been posed to you. Thank you. Gentlemen, are there any objections to the charge, Mr. Goudie?
I have none, my lord.
Mr. FitzPatrick?
Nor I, my lord.
Court will rise to wait the verdict of the jury then. I understand, gentlemen, the jury has arrived at its verdict. Would you ask the jury to come in, Mr. Drury, please?
Bring the jury back, please.
Members of the jury, have you answered the questions which were posed for you to answer?
Yes, we have, my lord.
Thank you, Mr. Foreman. Would you hand the answers up, please? Members of the jury, the answers that have been recorded here are as follows. To question number 1, the answer is no. The answer to question 2 is yes. The answer to question 3 is standing in position of danger, failed to keep proper lookout for his own safety, failed to warn oncoming traffic, failed to get far enough off the road. Answer to question number 4 is yes. The answer to question number 5 is deceased 30%, defendant 70%. Answer to question number 6A, under the Trustee Act, general damages $1,000, special damages $1,680. B, $35,300. Members of the jury, are those the answers to the questions that you have given to the court? Thank you. Are there any observations, gentlemen, about the answers which have been given by the jury? Is there any reason why I should not discharge them now?
I have no comment, my lord.
Nor I, my lord. Thank you.
Members of the jury, it has been a long day for you, and I'm going to release you now. There are certain proceedings that must take place before your answers are given effect to in a judgment, and I propose to deal with those matters with counsel immediately. But at this time, your services in this case have ended, and you are now free to go. May I, at this time, join with what counsel have said to you about the value of the jury system and our system of the administration of justice. I personally strongly believe in that system, and I hope that after your participation in this case, you share my belief. From time to time, men who are wiser than the 7 of us start to put movements afoot to do away with our jury system. They try first in case of civil juries, such as you are, and there are some who would do away with our jury system in criminal cases as well. If, after your experience in this case, you hold the view that I do, that a jury is a worthwhile part of our administration of justice, I hope when you hear such movements afoot that you register your dissent with your elected representatives. I feel that the jury system is a system that well merits being kept, and I think your services to your community in this case underscores the importance of the jury system. I understand from the registrar that your services at this assizes will no longer be required, since there is a new jury panel coming in next week. So I can advise you that you are now free to go. Your checks for your fees as jurors will be forwarded to you shortly. The amount of money that you will be paid obviously will not be sufficient compensation for the time, the trouble, and the inconvenience to which you've been put, but I would ask you to accept it in the form of an honorarium from the fellow members of your community for rendering an important service to your community. Thank you, members of the jury. You are now discharged and free to go.
Members of the jury are now excused from further duty and are free to go.
Gentlemen, is there a motion for judgment based upon the findings of the jury?
Yes, my lord, I move for judgment.
Okay. I make the total under the Trustee Act, general damages and out-of-pocket expenses to be $2,680. Which added to the assessment under the Fatal Accidents Act makes a total assessment $37,980. $75% of that sum is $26,586. That is by my calculation. Do you agree with those figures, gentlemen?
My lord, I recorded 70%, 70-30 as being the division
I'm
of
sorry, you're
liability.
quite correct. 70%. Well, 70% of that figure is $26,586.
Yes, my lord.
Thank you. There will therefore be a judgment for the plaintiff for $26,586. Gentlemen, I have to deal with the question of apportionment of the award under the Fatal Accidents Act. And if it is agreeable with you, counsel, I would think that perhaps it would be appropriate to deal with that matter in my chambers at a later time. Would that be agreeable to counsel?
Quite acceptable to me, my lord.
And is it also your lordship's wish that the question of costs be dealt with
Oh,
at that
no,
time?
I was going
too?
to ask you now if there is any reason why costs should not follow the event in the ordinary way.
Yes, my lord. 2 days before the commencement of trial, $28,000 was paid into court on behalf of the defendant. And I would ask that your lordship, in accordance with the rule, award the costs of the action up until that point to the plaintiff and the costs of the action, including counsel fee at trial, to the defendant after that point.
Mr. Goudie, what have you to say about the question of costs?
I'm basically in your lordship's hands and somewhat disabled by the fortunate circumstance that I haven't had to face into this particular problem frequently. One thing occurs to me, and I haven't my copy of the notice of payment in with me, but it runs in my mind that there may not have been any breakdown between the Trustee Act consideration or the Fatal Accidents Act consideration in the payment in. And if that is so, if it was just a lump sum payment, then it would be my submission that perhaps I have been denied the opportunity of actually considering it with reference to this verdict, in this sense, that if my friend didn't make allowance in his payment in for $700 under the Trustee Act net, then perhaps I did beat the payment in after all. I confess I may be only clutching at straws, and I'm not even certain of the factual ground because I don't know from memory whether there was any such breakdown, but it could, in my submission, be significant not to be considered by your lordship.
FitzPatrick.
My lord, were this a different type of case, and were there two plaintiffs involved and a claim requirement that the payment, the notice of payment in distinguish between their claims, and were the award to one of them slightly over, but the major award under, it would be my submission to your lordship that the defendant, having substantially succeeded, should get the substantial part of the costs. In this particular case, any extent to which the plaintiff is not caught by the payment in is so inconsequential that it would be in violation of the spirit of the rule were the defendant not to obtain the costs of the action after the point of the payment in.
Nothing further, Mr. Goudie?
No, don't think you, Lord.
Although the payment in was made at a late time, indeed 2 days before the trial opened, it appears to me that at that time the plaintiff was in the best position possible to be able to properly assess her claim and decide whether the payment in was an appropriate one. The rule is clear. Now that the old period of time permitted to accept the payment into court, that is to consider whether it should be accepted, no longer exists. I think that this is a case where the clear intention of the rule should be given effect to. Accordingly, I propose to order that the plaintiff shall have her costs of action up to and including 2 days prior to the commencement of this trial. The defendant shall have his costs from that time on, including counsel fee at trial. I will endorse the record accordingly.
Thank you, my lord.
Mr. Registrar, would you adjourn court till tomorrow morning?
Order. Oyez, oyez, oyez. All persons having anything further to do before my lord, the Queen's Justice of the Supreme Court of Ontario, may depart hence at this time and give their attendance here again tomorrow morning at 10 o'clock. God save the Queen.